So thank you all for joining us this morning to our webinar for education institutions, where we're going to be looking back at 2022 and looking forward to 2023. I'm just going to start with some quick introductions. So my name is Nicola Brown. I'm a partner at Mills & Reeve, specialising in employment advice to predominantly higher education institutions. Been doing that for several years now. Judy, over to you.
Hello, I'm Judy Roy. I'm a senior employment lawyer at Mills & Reeve. I also specialise in advice for education institutions, higher education, and also independent schools.
Thanks. So just before we start, just a few housekeeping reminders. The first one is that, as you will have seen on the invitation, that there is a recording of this session, which will be available to you afterwards. We should hopefully have a little bit of time at the end for some questions. So please put your questions into the question and answer session, which will be viewable only to you and to us as the panelists. If you could add your names when you put in the questions, and ideally your organisation, that would be helpful for us. And then, as I say, we'll try and fit in questions at the end. And when we get to the end of the session, there'll be a feedback survey at the end for you to complete, and we'd be really keen for you to complete that with your feedback. So what are we going to cover today? So as I say, it's a bit of a mixture between looking back at last year, 2022, and looking forward to this year, 2023. So we split the session into two parts. So looking back at last year, we're going to look first of all at redundancy, then we'll look at some investigation reports and legal privilege, holiday pay, you've seen lots in the press about that, menopause, then we'll look at COVID, religion and belief, and some changes to legislation that happened last year. And then we'll look forward to 2023 and look at some possible new legislation. Particularly, we'll look at minimum service levels during strikes, revocation of EU law, and dismissal and re-engagement. So these are topics that we've picked out as being key topics that we're seeing coming through with clients who we're advising at the moment, or where we're looking at things and thinking we think that this will have a big impact on the sector. So I'm just going to start by looking at some redundancy cases from last year. The first one is around volunteers for redundancy. So I'm conscious that a lot of you will be going through reorganisations at the moment. Now, in order to bring a claim for unfair dismissal, an individual needs to show that they've actually been dismissed, and that can be actual or constructive dismissal. And this case is a reminder that volunteering for redundancy is a dismissal. So the individual is agreeing to be dismissed by reason of redundancy rather than them resigning by reason of redundancy. So if the redundancy package is generous enough, then there's not usually much point in an employee bringing a claim for unfair dismissal, as they'd need to give credit for the redundancy package that they received. But really, if you're looking at settlement where you've got a voluntary severance, what you want to do is, if you want to reduce and i.e. eliminate the risk of claims by people who've been made voluntarily redundant, then you need to enter into a settlement agreement with them. And if you're going through a large-scale voluntary severance exercise, then it may well be that you want to line up a firm of solicitors that might be available in order to advise the employees, although that's not preventing the employees going elsewhere if they want to. So as I say, a quick reminder that voluntary severance is a dismissal for employment law purposes, and therefore if you want to remove the risk of employees bringing claims, then you need to look at settlement agreements. So moving on to the next case around the ACAS code. And this is a useful reminder about the scope of the ACAS code. So as we know, the ACAS code applies to grievances and dismissals for misconduct or poor performance. And it says clearly that it doesn't apply to redundancy dismissals, or rather it doesn't apply in this case to genuine redundancy dismissals. So if an employer fails to follow the ACAS code when it should have done, then tribunals, as I'm sure you're aware, have the power to uplift compensation by up to 25%. So in this particular case, there was an employee who was made redundant on the face of it, and she claimed that the ACAS code should apply to her dismissal. And it turned out that, in fact, a decision had been made to dismiss this individual employee a year before the actual redundancy exercise. So there'd been an agreement within the organisation that they would, in fact, dismiss her. And then they decided that, in fact, what they would do is they would make her redundant rather than going through a performance or indeed any other process. So the tribunal, will probably not surprisingly, found that the redundancy procedure was a sham, and that they said that this was a disciplinary situation in which the ACAS code should apply, and she was awarded a 25% uplift of compensation for the employer's failure to follow the code. So worth taking from this case that tribunals will look beyond the reason for dismissal given by the employer, and they may conclude in appropriate cases that the ACAS code should have applied even if the employer has framed it as a redundancy, if the redundancy was in fact a sham. So some takeaway points from this. It's important to be clear about the real reason for dismissal. You obviously want to do that for the purposes of the ACAS code, but you also want to do that for just general unfair dismissal law purposes. And obviously, if you're unsure about whether or not the ACAS code would apply, it's safest to act as if it does apply and to follow it to avoid the uplift. So that's a quick run through of those. Judy, over to you.
Okay, thank you. I'm going to look at a useful case about the limits of legal privilege and how that applies in the context of investigation reports. So just by way of a reminder, in an employment tribunal claim or a court claim, in almost all cases, there will be an order requiring the parties to disclose all relevant documents, whether those documents undermine or support their own case or the other side's case. But documents that are subject to legal privilege don't have to be disclosed. Legal privilege attaches to documents that are created for the dominant purpose of receiving legal advice or for litigation, and those documents also have to be confidential. I think we just move on to the next slide, which then brings up the relevant case, which I wanted to mention to you, which is the case of the University of Dundee and Chakraborty. So in this case, a grievance investigation report was prepared by a member of the academic staff. In effect, the report was finalised, but it wasn't given to the employee at that point. Around this time, the employee started legal proceedings for race discrimination. The investigation report was then sent to external legal advisors who reviewed it, and as a result of that, some changes were made in the light of the legal advice and also by the investigator themselves. They wanted to make some changes. At that point, the revised report was provided to the employee. It was actually apparent on the face of the report that it had been revised. It referred to this being a specific version, and also to the fact that there had been legal advice. The employee sought disclosure of the original report in the context of the legal proceedings. The university argued against that disclosure on the basis, they said, that in effect, what would happen is if the original version were compared with the revised version, then you'd be able to identify what the legal advice was, and therefore this was in effect overriding the legal privilege. In fact, the decision was that legal advice privilege couldn't apply in that way and did not apply retrospectively. And specifically, what was found was that the document, the original investigation report, had come into existence for the main purpose of considering the employee's grievance, not for the purpose of receiving legal advice or for litigation. And as I said earlier, to be legally privileged, a document has to be produced for the dominant purpose of obtaining legal advice or for litigation and be confidential. So I think the takeaway points from that are that employers would be well advised to involve their legal advisors early in investigations if they think that there's likely to be a need for legal advice further down the line. And secondly, if you're in a situation where you want to get legal advice and input, and on specific documents, then what you need to do is, first of all, make sure that those documents remain confidential. So, for instance, that means being careful not to circulate them internally beyond a very narrow or the narrowest possible group. And also, if you're going to seek legal advice, that should be done on the basis that a draft is produced for the purpose of obtaining legal advice, and preferably the document should actually be marked in that way, draft for the purpose of legal advice. So it's quite a complex area around when things are not privileged, but I think those are some useful pointers and reminders just to bear in mind going forward. Back to Nicola.
Thanks. So moving on to holiday pay. And I'm going to look at a couple of cases around this. So the first one is Mr. Smith and Pimlico Plumbers, who's been with us for some time. And in April last year, the case came back before the Court of Appeal again. So in this particular case, Mr. Smith was a plumbing and heating engineer, as you might remember, and he worked for Pimlico Plumbers for the best part of 6 years. Now, throughout that time, his employer maintained that he was a self-employed contractor and that therefore he wasn't entitled to holiday pay. So what he did, Mr. Smith, was he took regular periods of unpaid leave in order to have a break from work. Now, when his relationship with Pimlico Plumbers ended, he brought various tribunal claims against them, including for holiday pay. So the first thing he had to do was to show that he had the legal status of a worker rather than being self-employed in order to be protected and to have the working time regulations holiday entitlement. And you may remember that in 2018, the Supreme Court confirmed that he was a worker for the purposes of the Working Time Directive and the Employment Rights Act. So his holiday pay claim continued in the courts. And as you'll know, all employees in the UK are entitled, full-time employees are entitled to a minimum of 4 weeks paid annual leave under the Working Time Directive, which we'll call Euro leave, and then 1.6 weeks annual leave under domestic law. So the Pimlico Plumber case was only about the Euro leave, so the 4 weeks. So we already know from a previous case that if an employer refuses to pay for annual leave and therefore a worker doesn't take leave, the worker is entitled to carry forward that leave and be paid for it at the end of their employment. And the Court of Appeal here in this Pimlico Plumbers case said that the same principle applies to a worker who takes unpaid leave because their employer refuses to pay for it. So Mr. Smith, having been wrongly told he was self-employed and having taken unpaid leave over 6 years, was allowed to claim compensation for all of his Euro leave over that 6 years, both taken and untaken, going right back to the start of his contract. So by his calculations, that amounted to £74,000. So you'll appreciate that is quite clearly a considerable sum of money, and employees being able, or workers being able to claim back pay, the holiday pay that they haven't had since the start of their employment is obviously quite expensive. So the practical implications around this, what does it mean for employers? So quite clearly, the first thing you need to do is to make sure that you've correctly categorized all those who work for you, whether they're self-employed, workers, or employees. So make sure that you've got them in the right category. And then you need to check that they are receiving their paid leave that they're entitled to. And that includes encouraging them to take it and letting them know that they will lose it at the end of each holiday year if they haven't taken it. So very clear annual leave policies and procedures will help a great deal on this. So that's the actual leave for people who you might not think are workers. Second case I want to look at is the case of Harper Trust in Brazil, which you will have seen a lot of in the press. And this is a case that concerns part-year workers. So in July 2022, the Supreme Court looked at the correct way to calculate holiday pay for workers with irregular hours. And so, for example, staff working on permanent term time only contracts, which they called part-year workers. Just sort of pausing there, the Harper Trust case doesn't apply to employees who are working regular hours. So in this particular case, in Harper Trust, the employer wanted to prorata the claimant's holiday entitlement so that it reflected the hours that she actually works. And they did this by using the commonly used multiplier of 12.07%, which is the proportion that 5.6 weeks leave bears to a full working year. That's the method that some employers have used in the past to pro-rata holiday entitlement for part-time workers, and it was the method that was originally laid down in the ACAS guidance, but which has now been withdrawn. So the Supreme Court in Brazil said that this 12.07% didn't tie in with the working time regulations, and they said that the claimant was entitled to 5.6 weeks holiday per year, regardless of the hours that she actually worked. And they said that to calculate holiday pay for part-year workers, what you need to do is you need to calculate their average weekly pay in the 52 weeks immediately before their holiday, but you ignore any weeks in which they don't work. And you can go back up to 2 years to find the 52 weeks when they have been working. So in practice, as you can see, you're going to end up going back, ignoring the weeks that they don't work, looking at the weeks they work over a 2-year period to find 52 weeks that they've been working. So that this means that employees or workers who are working for part of a year will in fact receive more holiday entitlement and more pay than they would have done under the previous arrangement. So the higher the number of non-working weeks, the greater the holiday pay is as a percentage of annual working time and earnings. So for those of you within the education sector, this is quite clearly going to be most relevant for people who you have on term time only contracts. So for example, hourly paid lecturers or visiting lecturers, and it's worth thinking about whether you need to do anything about their holiday pay at the moment. And just to repeat that this doesn't impact upon standard part-time workers who work throughout the year for whom nothing has changed. So that's the Harper Trust and Brazil case. And then the question is, what should you do now? Should you change things? Towards the end of last year, we were saying, well, you probably should be looking at changing things. But we've had some government consultation, which was launched at the beginning of this year. And the aim of this government consultation, as you can see on the slide, is to reverse Brazil and to reduce the disparity between part-time and part-year workers. And the government itself has estimated that this decision will benefit, so the Harper Brazil case will benefit between 320,000 and 500,000 permanent term time and 0 hours contract workers. And they think that of those, 37% of these workers work in the education sector. So quite a number of employees are impacted within the education sector by the Harper Trust and Brazil case. So as I say, the aim behind the government consultation is to reverse the impact of the Harper Trust and Brazil case. And what the government has done is it's proposed a 2-step calculation for accrual of holiday pay for part-year and irregular hours workers. So what they've said you should do is you work out the total hours worked in the previous 52 weeks. And unlike the case that I've just referred to, you include weeks when they're not working. So you look at the total hours they've worked in the previous 52 weeks, and then you multiply that by 12.07% to produce their holiday entitlement in hours. So that's how they plan to do this. There's no plan to sort out other problems with the working time regulations and holiday. So at the moment, the consultation is just limited to reducing the impact of Harper Trust and Brazil. And the consultation closes on the 9th of March, 2023. So the question is, should you be making changes now? The Supreme Court decision in Harper Trust and Brazil is binding for now, and it's unlikely that any changes introduced as a result of government consultation will be retrospective. So you might want to think about whether or not you do need to change things now, or whether you're going to await the outcome of the decision of the government's consultation. So it's worth keeping an eye on developments and deciding what to do. And it's also worth feeding into the consultation, both the government consultation, which I've put a link on to the slide, and there's also UCA consultation for those of you within the higher education sector. So I recommend that you feed into both of those as to the impact that Harper Trust and Brazil will have on your calculation of holiday pay for part-year workers. So Judy.
Thanks, Nicola. Sorry, just reminding myself to unmute. So my topic now is the menopause, and well, you may well think, well, there's nothing new about the menopause. That's part of life, and indeed, that's absolutely correct. But what is new is the amount of attention that the menopause has been receiving over the last year, 18 months or so, in media, government, the workplace, and more generally. I think it's probably a sign of an increasing recognition and willingness to talk about the substantial impact that it can have on some women. By no means all women. For some will be able to go through the menopause with little or no problems, but for some it can be very significant and have a particular effect on working life. So in many ways, it's good to see these things being talked about for the benefit of everybody. As an indication of that change, I think it's really significant to note that in 2021, there was a 44% increase in the number of tribunal cases citing the menopause as a factor. At the moment, the menopause isn't a specific protected characteristic. But if an individual is put at a disadvantage and treated less favourably because of their menopause symptoms, that could be discrimination related to a number of characteristics which are currently protected under the Equality Act. So, for example, age, disability, potentially gender reassignment, and sex. In terms of disability, as you'll appreciate, in order to have that protected characteristic, it's necessary for the symptoms that are suffered to have a substantial adverse effect on normal day-to-day activities lasting for at least 12 months. And there is case law over the last 12 months which has specifically found, and I don't think this is any great surprise, that the symptoms of the menopause, if severe enough, can certainly be capable of amounting to a disability under the Equality Act. So just moving on to looking at what has been happening in government. On the next slide, I've referred to the government's response to the Women and Equalities Committee report on menopause and the workplace, which was published recently. I should say there's been a lot of activity in government, so I'm not going to go into all of that, but just focus on this, which is really the key thing at the moment. I think the sort of key points to take away from the government's response are that I suppose the headline recommendations have, at least for the moment, been rejected by the government. So one of the recommendations was to enter into a consultation around making menopause a specific protected characteristic. That has been rejected for a number of reasons. First of all, around, as I was saying earlier, there are already protected characteristics under the Equality Act which are relevant to the menopause and menopausal symptoms. And also there was a concern about the possibility of a sensitive making the comparison of the menopause as a condition with other conditions, and whether that would lead on to arguments that specific other conditions should themselves become protected characteristics. So there we are. At the moment, that's not moving forward. There was also a recommendation for there to be a pilot menopause leave policy to see how the implications of that would work out. That's been rejected. Doesn't, of course, mean that employers themselves can't look at developing something around that, but that's not being taken forward by the government. What has been accepted and is being put in place is the appointment of a menopause employment champion, whose role is, and I'll just read it out, to give a voice to menopausal women, promote their economic contribution, and work with employers to keep them in work and progressing. So I think that indicates at least a commitment to highlighting this area going forward, and hopefully that the champion will keep that in the public view and the government view as well. So what about action points for employers? Well, I've put a few suggestions on the next slide. I mean, first of all, take menopausal symptoms seriously, because they can be very serious and can constitute a disability. But also, I think on a very sort of practical, real world level, there's a lot of merit for the benefit of everybody in terms of supporting women in this situation, particularly in the workplace. Have open conversations with employees. I think that's really important, but it can be quite difficult because some of this is sensitive. So there's something around managers perhaps needing training, or thinking about having specific people in the workplace who are sort of identified as individuals to whom somebody who is suffering from menopausal symptoms or has concerns can speak to. So people who are able to have those conversations perhaps more easily than others might be. Do review the supports that you have in place for women experiencing the menopause, and seek medical advice if any issues arise before making significant decisions or thinking about what support may or may not be appropriate. Could be occupational health, could also be external specialists in this area. And consider a menopause policy. I know that we've all got a lot of policies, don't necessarily want to add more, but there could be something around a policy, fairly short, fairly concise, but helping managers and staff to understand the issues associated with the menopause, and in particular to signpost and highlight areas and routes for getting support and assistance if somebody is having problems. So quite a few things to think about there. And then my next topic is COVID. I'm just going to speak about this very briefly. I mean, it would be lovely to think that we have moved on completely from the pandemic and can put it all behind us, but unfortunately, things don't work quite like that. And of course, you know, some individuals are suffering from long COVID, which in itself can have fairly debilitating ongoing symptoms and lead to specific other medical conditions. So I just wanted to highlight that there has been a case recently this year, again, not surprising, but just worth noting, in which it was held that the symptoms of long COVID can amount to a disability under the Equality Act, provided that the requirements that I outlined earlier are met. And then I was just going to mention one case, which I think should be reassuring for employers. This is Mr. Rogers and Leeds laser cutting. During the pandemic, Mr. Rogers was dismissed for leaving work and refusing to return to work, to the workplace, because he was concerned about his vulnerable baby and child. He had less than 2 years service, which meant that, as you will appreciate, he didn't have the normal standard right to bring an unfair dismissal claim. Instead, he brought a claim for automatic unfair dismissal for health and safety reasons. And that type of claim, somebody can bring from day one of employment. They don't have to have any specific qualifying period. And a dismissal in those circumstances is automatically unfair, where the employee reasonably believed that there was a serious and imminent danger at work, and they left the workplace or refused to return to protect themselves or others from danger. In Mr. Rogers' case, it was accepted that he had genuine concerns about being in the workplace because of the risks associated with COVID and the fact that he had vulnerable children at home. However, crucially, it was held that his genuine concerns were not reasonable, and in particular because the employer had at that stage complied with all the government guidance and requirements for safety in the workplace. So each case is decided very much on its own facts. So there's no absolute golden rule here, but I think it's a helpful case and just illustrates the way that this type of issue is approached. And then I think back to Nicola. Oh no, in fact, yes.
Okay, so I'm going to start by looking at religion or belief. So if and I'm just going to recap because I've been sitting chatting to myself quite happily, although my computer showed that I wasn't on mute. Thank you for in the questions putting in that I was. So a quick recap about religion or belief. So religion or belief is one of the 9 protected characteristics. And religion, I'll put the definition on the slide. Religion means any religion, and a reference to religion includes a reference to a lack of religion. And belief, it means any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. And the key case in this area is a case from 2010, Granger and Nicholson. And I thought it was worth going back and reminding oneself about the key principles that came out of that case, because that then feeds through to the other cases that I'm going to deal with in a minute. So the first one is that the belief must be genuinely held. So it needs to be a genuinely held belief by the individual. Second point is that it needs to be a belief, not an opinion or viewpoint, which is based on the current state of information available. So it has to be a belief. And then it must be a belief as to a weighty and substantial aspect of human life and behaviour. Fourthly, it must contain a certain level of cogency, seriousness, cohesion, and importance. And finally, it must be worthy of respect in a democratic society, not incompatible with human dignity, and not conflict with the fundamental rights of others. So those are the 5 points that came out of Granger and Nicholson. And as I say, they're the key points when you're looking at religion or belief claims. So looking at gender critical beliefs, and that's been the focus of no less than 4 employment tribunal judgments in July last year. And I'm going to look at 2 of those in detail today. The first one, Forstater, I'm going to look at twice. First, the extent of the protection. So as I say, we're looking at gender critical beliefs here. So someone with gender critical beliefs believes that an individual's biological sex is fixed and is separate from their gender identity. And you'll be aware that it's a subject that's attracted a lot of media attention. In 2021, the EAT held that a gender critical belief in principle can qualify as a philosophical belief, and that's the Forstater case, which is on the slide. So the fact that a belief may be controversial or upsetting to others doesn't stop it from being protected. But the EAT stressed that individuals holding gender critical beliefs still need to comply with the law, and it was still open to employers to try and provide a safe environment for trans people by setting appropriate limits on how those beliefs were expressed. Second case I want to look at is the case of McCreath, which is a decision of the Employment Appeal Tribunal. Now, this is, as there was also in last year. So Mr. McCreath was a Christian doctor who assessed claimants for benefits for the Department for Work and Pensions. And he believes that a person cannot change their gender at will, and he does not believe in transgenderism. So as such, he refused to address transgender people by their chosen pronoun, and that was contrary to the Department for Work and Pensions policy. So the DWP insisted that he follow the policy, and he said he wouldn't follow the policy, and he then brought claims of both direct and indirect discrimination and harassment on the basis of his beliefs. So the first question that the Employment Appeal Tribunal had to look at was whether his beliefs qualified for protection. Were they a philosophical belief? And they said yes, they were, following the EAT decision on Forstater, which I just referred to a few minutes ago. So then they moved on to look at whether he had been discriminated against on the basis of those beliefs. And both his direct and indirect discrimination claims failed. And just going through why they failed. So firstly, on the direct discrimination point, the EAT drew a distinction between the fact of his beliefs and the way in which he wanted to express those beliefs. So they said that anyone who was not prepared to address service users with their preferred pronoun would have been treated the same way by the Department for Work and Pensions, regardless of whether they shared his beliefs. So the reason he was treated in that way wasn't because of his beliefs, it was because he refused to address people by their chosen pronoun. And anyone who had refused to do that would have been treated in the same way. So his direct discrimination claim failed. They then moved on to look at indirect discrimination claim. They said that potentially the requirement to use the chosen pronouns was potentially indirect discrimination. It was a provision, criterion, or practice which had a disproportionate effect upon people of a particular religion or belief. And they said, but let's look at justification for that. And they thought that there was justification for that policy and they said it was a necessary and proportionate means of achieving a legitimate aim, which is the objective justification defence that applies to indirect discrimination cases. So they said the legitimate aim was to ensure that transgender service users were treated with respect and in accordance with their rights, and so that they could provide a service that promoted equal opportunities. And they said that they believed that there was objective justification for that. And there were 5 features that explained why the employer's justification defence succeeded, which I've put on the slide. So the first one is that they had a clear policy on what they expected, and they could show why that policy had been adopted. They also said that the other staff were not hostile to Dr. McCreath because of his beliefs, and in fact they listened to what he had to say with respect. Dr. McCreath had been given some time to reflect on his position and to decide whether or not he was going to adjust his position in the light of the position that the DWP were taking. And the DWP had explored alternative solutions to avoid a clash of rights, though none of those were actually workable. So that's the case in the Employment Appeal Tribunal. Dr. McCreath has said he will be appealing to the Court of Appeal, so we might hear more about that in due course. So going back to Forstater, so the week after McCreath came, happened, then there was the case, the Employment Tribunal came back to look at Forstater. So Forstater is the case which I referred to at the beginning, where the Employment Appeal Tribunal overruled the earlier Employment Tribunal and said that a gender critical belief can in principle qualify as a philosophical belief. So the Employment Appeal Tribunal said that Ms. Forstater had a belief that was potentially protected. And so what the Employment Appeal Tribunal did was they sent the case back to the tribunal to decide whether the employer had discriminated against her on the grounds of her protected gender critical beliefs. Now, this Employment Tribunal decision, as you can see from the slide, is only a first instance decision, so it's not binding on other tribunals, and quite clearly it's generated a lot of attention in the press and on social media, which is why I wanted to refer to it. So Ms. Forstater was a researcher, and she lost her contract as a visiting fellow after she expressed a series of gender critical views on Twitter and at work. And the employer argued that the way in which she had expressed her beliefs, not the fact that she held them, meant that they weren't going to renew her contract. The tribunal disagreed, and Ms. Forstater won her direct discrimination claim in the Employment Tribunal. So the tribunal said that her tweets and comments were not much more than asserting her beliefs. And they said that if a belief was protected, then a simple statement of that belief must also be protected. Now, in some cases, Ms. Forstater comments had been provocative or mocking, but the tribunal said that this was common currency of debate, I quote, and again, that this was not objectively offensive or unreasonable. So as I say, Forstater is an employment tribunal decision. It's not binding on other tribunals, but it's just interesting to look at how the tribunal approached that particular question. So some practical tips around this. Where does it leave employers? It's difficult to come up with hard and fast rules. Isn't that what lawyers often say? It depends upon the facts of the case. But there are some points that come out. So quite clearly, you as employers can use your policies to set out your values and what you consider to be acceptable behaviours, both in the workplace and on social media. And in McCreath, the employer who won had a clear policy on how transgender service users should be treated, and they could show why that policy had been adopted. In Forstater, the employer who lost didn't have a policy saying what staff could and couldn't say, and they actually engaged lively debate about non-work issues. Clearly, any policies that you have need to be proportionate, and they need to be applied equally to all religious groups. And it's quite clearly important that you train your staff to respect each other's beliefs and opinions and to promote diversity. It's not for employers or the courts to express views on the merits of the trans debate, and employers shouldn't step into the ring, but instead focus on how to sort of sensitively try to balance the competing rights and ensure that opposing views are treated consistently. The other point that's worth bearing in mind is it is worth taking legal advice before any action against employees who are expressing beliefs that may amount to philosophical beliefs. It's worth looking at whether the action that you're taking is proportionate, or sometimes can something less intrusive be done. So, for example, Ms. Forstatter agreed that she would put a disclaimer on her Twitter bio to say that her tweets were not the views of the employer, and she also agreed to stop bringing campaigning leaflets into the office. So, Judy, I think you're going to look at some changes in legislation.
Yes, thank you. So so we've looked at some cases, and now just going to touch briefly on some changes in legislation in 2022. In fact, the COVID pandemic slowed parliamentary activity on matters not relating to COVID for quite a while. So in that sense, in the employment front, 2022 was a relatively quiet year. So I'm just going to pick up on two areas of change which I've put on the slide. So first of all, I don't need to say to you, I'm sure, that industrial action was a hot topic last year, and it's going to continue that way this year. It affected pretty much everybody, I think, one way or another. For instance, anybody who used the railways would have been affected. And of course, the government's sympathetic to that and concerned about the impact. So in July 2022, introduced a couple of changes in the industrial action rules. In particular, a change was made to allow agency workers to be engaged to cover for striking workers. Previously, that had been something that was potentially a criminal offence, so a big change there. I mean, no doubt that will be helpful to some employers, but clearly it will be of limited benefit because agency workers will only be able to cover for certain types of jobs. Obviously not for highly skilled, very jobs that require very specific training within an employer, but may well be helpful for jobs that are more amenable to somebody coming in and picking up the reins quickly, whether that's something around security, catering, that type of thing. Further, the government increased the limit on damages that unions are liable to pay for unofficial action. So the maximum is increased from 250,000 to 1 million. So even more important for unions to make sure that they're getting everything right under the legislation when they're putting in place what they need to do in order to be able to take official action. So you might have seen recently, for example, that the Royal Mail unions have had to cancel some planned action over the next few weeks because of problems they'd encountered in their preparatory work, put it that way. And then a change in the fit note rules. Again, in July 2022, the rules were changed to allow a greater range of health professionals to issue fit notes. So now, as well as GPs, can be nurses, occupational therapists, pharmacists and physios. I think recognising the value of the work that those individuals are doing, and also to take some pressure off GPs who, as I think we all know, are under great pressure at the moment. So an attempt to help ease up some blockages there, I think. So worth checking your policies, or when you're next updating policies and procedures around sickness absence, worth just making sure that you're referring to the up-to-date list of people who can give fit notes. I'm then just going to refer to one area where change was anticipated and then didn't happen, but I think just still worth touching on briefly because what came out of the government's response to the consultation. So you might remember that the government launched a big consultation on employment status. and then responded to that consultation in July 2022. This was all about employment status in terms of employees, workers, and the genuinely self-employed independent contractors. As we know, employees have the highest level of legal protection, genuinely self-employed have the lowest, and we have workers in the middle. The consultation was around, are those categories the right categories? And also, are the definitions within the legislation, is it clear enough? Does it work? So, as I said, the outcome of the consultation was that nothing is going to change, which, you know, may be viewed as a good thing or not. But I think the key messages that I took away from the government's response, which I think are just worth being aware of, is that they decided that the categories, those three categories, are the correct categories. And that they do work well to balance the needs of employers to have flexibility and the needs of individuals who are providing work to businesses and other organisations. However, it was recognised that there is work that needs to be done around the definitions of these categories, because it's not clear in the legislation, and that's why we've got a huge raft of case law, which employers and lawyers have to try to pick through if they're trying to work out into which category somebody properly falls. So there was a clear signalling that at some point the intention would be to clarify and tighten up those definitions in the legislation, but the government said not now, because there's too much going on in the economy, and it would be an additional burden for employers and also for individuals to start tinkering with those fundamental issues at the moment. So what the government did do has been to publish employment status guidance, which you can find on its website, which is a useful digest of the lessons that have come out of the case law. So it's not new, there's nothing new in there, but it's a useful compendium of bringing the case law decisions together, and worth looking at if you're having to look at these issues. And then we are going to move on to our short crystal ball gazing section, which is what to look out for in 2023. I was going to start with some possible new legislation. As I mentioned a moment ago, COVID slowed down parliamentary business for a while on matters not relating to COVID, but things are picking up at speed again. In particular, the government is supporting some bills that have been put forward by individual MPs, known as private members' bills. Quite often private members' bills just don't get anywhere, because if they don't have government support, then they don't get parliamentary time and not enough votes. But these bills do have government support, so there's a reasonable prospect that they will come into legislation. However, having said that, I'm not going to go into this in any detail, because they might not get through, and also they might change on the way through Parliament. But I just want to sort of headline what the topics are and what to look out for, because they're reasonably significant if they do come into law. So first of all, there's a proposal for the right to request flexible working to become a day one right, no qualifying period, and also proposing other changes in there, for instance, around up to 2 requests being able to be made in 1 year. And then the proposal for a new legal duty for employers to take all reasonable steps to prevent sexual harassment at work, so a positive duty to take steps, and also to reintroduce an employer's liability for third-party harassment. You might remember that we had that a while ago, and then it was dropped out of legislation. Well, the proposal is to bring it back in, and also for that to apply where third-party harassment occurs on one occasion, which would be quite a significant change. Also a proposal to extend redundancy protection for new parents. So as you know, at the moment, a woman returning from maternity leave effectively has a priority right to suitable alternative employment if she is if her post is redundant. The proposal is to extend the period of protection from the time at which the pregnancy is notified to the employer for a specified period of time after the return to work, which which looks like it could be as long as 18 months. And there are similar proposals around people returning from shared parental leave and adoption leave. Again, potentially significant change. Also, carers leave, a proposal for 1 week's unpaid leave for individuals who need to provide care for dependents with long-term care needs. And then in relation to neonatal leave and pay, the proposal is a framework, a new framework to support parents of premature and sick babies. And the proposal is 1 week's leave for each week in neonatal care, up to a total of 12 weeks, and that's a day one right. And then a proposal for that to be paid at a statutory rate after a qualifying period of 26 weeks in continuous employment. And then finally, a bill which would bring into law a right to paid time off for fertility treatment.
Okay, so I'm going to go back to industrial action and to look at the minimum service levels during strikes. So this is a bill which is currently going through the House of Lords. It's been through the House of Commons and is now in the House of Lords. And you'll have seen stuff in the press about it. But what it does is it plans to set minimum service levels for fire, ambulance and rail services. So those levels to be arrived at following consultation, which is due to take place. There are then a range of other sectors that are mentioned in the bill, comprising other health services, other transport services, education, which I'll come back to in a minute, nuclear decommissioning and waste management, and border security. And in respect of them, the government expects to continue to reach voluntary agreements within those sectors. But if voluntary agreements aren't reached, then minimum service levels could still be imposed as a fallback option. So as I've said, within the education sector, we think that it's likely to apply to schools, but probably not within higher education. So what's the bill actually proposing? What it's doing is it's proposing that there are minimum service levels which are imposed, and that basically there be regulations which defines the categories of workers who could be told to work in the event of a strike, and to ensure a minimum level of service, as I say. So if the individuals fail to comply with the work notice, then that worker would be treated as having taken part in unofficial industrial action, and they'd lose their protection against unfair dismissal, and the union would lose its immunity from being sued by the employer. Now, as currently drafted, the whole of the bill would become law on the day that it receives royal assent. But in addition, it's got some slightly odd transitional provisions. So in addition, it enables minimum service levels to be imposed even if the industrial action ballot took place before the bill became law, or the necessary regulations were not made until after the notice of strike action was given to the employer. So some element of retrospective effect. Judy, I think you're going to look at EU law.
Yes, I am. I'm sure it's everybody's favourite topic. So just briefly, in September 2022, the government published a bill with the intention of accelerating the pace at which retained EU law is scrutinised and replaced by domestic UK legislation after Brexit. The current draft of the bill includes a sunset date of the 31st of December 2023, by which EU laws in secondary legislation, so that means things like regulations and statutory instruments, not acts of parliament, would automatically fall away unless they are expressly retained. So clearly this includes some really important pieces of employment legislation, such as GP, the working time regulations, agency workers regulations, fixed term employees regulations, etc. I think there's big questions about whether this is practically and politically possible. at the moment, out of 2,470 numbers on the site, pieces of EU law which would fall into this category, the number that have so far been scrutinised and addressed, as it were, is around 400. So that gives an indication of the change of pace that we're talking about, if this is going to be achievable. And also, some of the legislation which is covered, particularly in the employment sphere, is actually viewed as helpful and valued within the UK quite significantly. So one would wonder the extent to which the government would actually want to or could make significant changes there. There's also a very significant risk of increasing legal uncertainty, particularly as we progress through the year. If the legislation is potentially going to drop away or it needs to be changed quickly, what is that going to mean for what replaces it? And as I said earlier, it's interesting because when I was talking about the review of the employment status, the government was very clear there that what they didn't want to do was to tinker with legislation in a way which was actually going to make things more difficult for organisations and businesses during this time when there are difficulties in the economy. So there's a bit of tension there, I think, in the government's position. So we will see what happens. If I had a crystal ball, I suspect that date of the 31st of December 2023, as a minimum, may change and be pushed out.
Right. So the final thing I was just going to briefly touch on was the draft code of practice on dismissal and re-engagement. The key points are set out on the slide. The purpose of it was to deal with the problems that arose from the mass dismissals at P&O Ferries. And when you're looking at dismissal and re-engagement, if you're looking at potentially a large number of dismissals and re-engagement, then you're into the collective consultation provisions that apply on redundancies in its broadest definition. So this code of practice basically requires employers to go through a similar process to that collective consultation process, but also for employers to keep their minds open during that process as to whether or not dismissal and re-engagement is something that should take place, or whether there are other alternatives available. So I was just going to briefly touch on that and indicate that to you with the consultation due to close in April this year. So that's a really quick recap of some things that have taken place in 2022. A quick look forwards to some that's going to take place in 2023. I'm sure that there'll be lots more things that happen that we haven't highlighted in the time available. So do keep an eye out for what's changing on the employment law field. Thank you all very much.